A federal judge in Texas just ruled that a core piece of the National Firearms Act is unconstitutional. But before you believe headlines claiming this permanently blocks suppressor and short-barreled rifle restrictions nationwide, you need to understand what actually happened, because the real ruling is both more interesting and considerably narrower than that. On August 5, 2026, Judge James Wesley Hendrickx of the Northern District of Texas ruled in the consolidated cases of Silencer Shop Foundation versus ATF and Jensen versus ATF that the registration and approval requirements attached to suppressors, short-barreled rifles, short-barreled shotguns, and a category called any other weapons exceed what Congress is constitutionally allowed to do, based on a legal theory that has nothing directly to do with the Second Amendment. This is one of those rulings where the actual reasoning is genuinely clever and worth understanding on its own terms. A story about tax law and legislative procedure colliding almost by accident, rather than the sweeping constitutional gun rights showdown some headlines are describing it as. I'm going to walk you through exactly why this ruling happened, the specific piece of legislative history that made it possible, what the court deliberately chose not to decide, and why the words permanently and nationwide don't actually describe what this ruling does. Before we get into it, if you want the actual scope of a major ruling explained accurately instead of inflated for clicks, subscribe and turn on notifications right now. This is exactly the kind of story where the real legal reasoning is genuinely fascinating on its own terms, without needing to exaggerate what it actually accomplished, and getting the actual scope right matters enormously if you're a suppressor or SBR owner trying to figure out what this means for you specifically. Let's get into exactly why a federal judge concluded this. Here is the legal theory at the heart of this entire ruling, and it starts with a Supreme Court case from nearly 90 years ago. In 1937, in a case called Sonzinski versus United States, the Supreme Court upheld the original 1934 National Firearms Act specifically because it was structured as a tax. Congress doesn't have unlimited power to simply ban categories of weapons outright under the Constitution's enumerated powers, but it does have broad authority to tax. And the court in Sonzinski reasoned that the NFA's $200 tax on transferring or making items like machine guns, suppressors, and short-barreled rifles, along with the registration paperwork required to administer that tax, was a legitimate exercise of the taxing power, not a disguised attempt to regulate or ban weapons outright. That legal foundation, tax-first registration machinery, exists to support the tax, has been the constitutional basis for the entire NFA registration system for close to 90 years. The first segment of the story is what changed that foundation in 2025, because this ruling doesn't exist without a specific piece of legislation passed the year before. As part of a large piece of legislation called the One Big Beautiful Bill Act, Congress reduced the NFA's making and transfer tax on suppressors, short-barreled rifles, short-barreled shotguns, and any other weapons all the way down to $0, effective January 1st, 2026. The original version of that legislation actually attempted to go further and fully deregulate these categories, removing them from NFA oversight entirely. But on July 3, 2025, the Senate parliamentarian, Elizabeth McDonough, ruled that the full deregulation language violated the Byrd Rule, a procedural rule governing what can be included in a reconciliation bill, which requires provisions to be sufficiently related to the budget rather than general policy changes. The deregulation language got stripped out under that ruling. The tax cut itself survived and became law. The result was a strange, arguably broken arrangement. The tax that justified the entire registration system dropped to $0, while every piece of paperwork, fingerprinting, photographs, notifying local law enforcement, and waiting for ATF approval remained fully in place, all technically still there to enforce collection of a tax that no longer existed. The second segment is exactly how Judge Hendrickx reasoned through that strange arrangement to reach his conclusion. The plaintiffs, which included the Second Amendment Foundation, the Firearms Policy Coalition, several other advocacy groups, firearms industry members including B&T USA, Palmetto State Armory, and Silencer Co., and 15 states, argued that once Congress zeroed out the tax, the entire constitutional justification the Supreme Court relied on in Sonzinski disappeared along with it. If the NFA's registration machinery only exists, constitutionally speaking, to support collection of a tax, and that tax is now zero, the machinery no longer has a valid constitutional basis to keep operating, since Congress can't use its taxing power to justify a regulatory scheme that collects no actual revenue. Judge Hendrickx agreed, writing that the regulatory provisions must be enjoined as unconstitutional because they now exceed Congress's enumerated powers, given that the tax to which they were constitutionally tethered no longer generates any money whatsoever. The opinion reportedly stated this problem directly, that because the current version of the NFA generates zero revenue from these specific categories of firearms, its regulatory apparatus, the fingerprinting, the photographs, the chief law enforcement officer notification, the waiting period, can no longer be justified as merely incidental machinery supporting a legitimate tax, the exact justification Sunzinski required back in 1937. The third segment is what the court deliberately chose not to decide, and this detail matters enormously for understanding the actual scope of the ruling. Both sets of plaintiffs had also raised Second Amendment arguments, claiming suppressors and short-barreled rifles are constitutionally protected arms, and that NFA registration violates the right to keep and bear them. At a motions hearing held on July 7th, all parties reportedly agreed the court could resolve the case without reaching that constitutional question at all, if it ruled for the plaintiffs on the narrower enumerated powers argument first. Judge Hendrickx took that path deliberately, citing the long-standing judicial principle that courts should avoid deciding constitutional questions when a case can be resolved on narrower grounds. This means the ruling says absolutely nothing about whether suppressors or short-barreled rifles are protected by the Second Amendment, whether NFA registration would satisfy the historical analog test from Bruin, or whether these items count as dangerous and unusual weapons outside constitutional protection. Every one of those questions remains completely open for future litigation, especially if this ruling gets reversed on appeal and the Second Amendment arguments become necessary again. The fourth segment is exactly who this ruling actually covers, because the words permanently and nationwide massively overstate what happened here. Judge Hendrickx explicitly limited his injunction to the specific plaintiffs in these two consolidated cases, along with their members and customers. That means the advocacy organizations that sued, their documented members, and customers of the specific companies that were plaintiffs, B&T USA, Palmetto State Armory, and Silencer Co. among them, are covered by this injunction. It does not automatically extend to every gun owner in the country, and it does not mean the NFA's registration requirements have been struck down as a general matter for anyone who happens to want one. If you're not a member of one of the plaintiff organizations or a customer of one of the specific named companies, this ruling, as written, does not currently protect you from NFA enforcement. The fifth segment is the word permanently, because even for the people this ruling does cover, permanently isn't accurate yet either. Judge Hendrickx stayed his own injunction for 7 days from the ruling, specifically to give the federal government time to seek emergency relief from the Fifth Circuit Court of Appeals before the injunction actually takes effect. That stay period runs out around August 12th or 13th, meaning as of the ruling's issuance, the injunction wasn't even operative yet, let alone permanent in any final sense. The Department of Justice retains a clear path to appeal this decision to the Fifth Circuit. And if they do, and if the Fifth Circuit disagrees with Judge Hendrickx's Article I reasoning, this entire ruling could be reversed, which is precisely why the court avoided deciding the Second Amendment questions, preserving them for exactly that scenario. The sixth segment is what this means practically right now, this week, for anyone who owns or is considering one of these items. Until the stay actually lapses, and unless a higher court extends it further, the existing NFA process continues applying exactly as it did before this ruling. Fingerprints, background check, waiting period, ATF approval, all of it. Even once the stay does lapse for the specific plaintiffs and their covered members and customers, an NFA violation for someone not covered by this injunction still carries serious criminal exposure, up to 10 years in prison, a $10,000 fine, and forfeiture of the firearm, with a felony conviction triggering a lifetime firearms ban on top of that. Several retailers have already begun running marketing suggesting no more Form 4, No more registry, no more waiting. And if you look closely at that kind of marketing, the responsible versions include a conditional phrase, once the injunction goes into effect, language that is doing an enormous amount of legal work that a quick glance at an advertisement can easily miss. Let's step back and name the single thread running through this entire ruling. This was never actually a case about whether the Second Amendment protects suppressors or short-barreled rifles. It was a case about a specific, almost accidental legislative quirk. Congress zeroing out a tax while a procedural rule stripped out the deregulation language that was supposed to accompany it, leaving behind a regulatory scheme that a federal judge found could no longer justify itself constitutionally once its revenue purpose disappeared. That is a genuinely significant legal development, and the reasoning, if it survives appeal, could meaningfully reshape how these specific categories of firearms get regulated. But it is party-specific, currently stayed, headed to a higher court, and deliberately silent on the broader constitutional questions gun rights advocates actually care about most. Understanding that distinction between a real and important ruling and the exaggerated version circulating online is exactly what separates knowing what happened from repeating a headline that promises more than the actual opinion delivers. It's worth appreciating the deliberate legal strategy both sides agreed to here, because it tells you something about how this litigation is likely to unfold going forward. By resolving the case on the narrower enumerated powers argument and explicitly avoiding the Second Amendment questions, the court left those constitutional arguments completely untouched and available for a future round of litigation, particularly if the Fifth Circuit reverses this ruling on appeal. That means even if the government wins on appeal by successfully defending Congress's authority to keep the registration machinery running despite the zeroed-out tax, the plaintiffs still have their full Second Amendment case waiting in reserve, essentially giving them two separate paths to the same ultimate goal rather than betting everything on one argument. This kind of layered litigation strategy, winning on the narrowest available ground while preserving broader arguments for later, is common in complex constitutional litigation, and it's worth watching for as this specific case and the broader legal effort to challenge NFA regulation more generally continues developing over the coming months. If there's one thing worth taking from this breakdown, it's that even a genuinely major ruling deserves an accurate description of its actual scope, not an inflated one. Do not build a short-barreled rifle in your garage this month because you read a headline claiming the NFA is permanently gone, and do not assume you're personally covered by this injunction unless you can specifically confirm you're a member of one of the named plaintiff organizations or a customer of one of the specific named companies. If this helped you understand what this ruling actually does and doesn't do, share it with someone who's already seen the exaggerated version. Subscribe so you catch the Fifth Circuit's response the moment it happens, and I will see you in the next one.